$1.9 billion, $1,900,000,000. That is the estimated value of the narcotics and human smuggling operation that federal prosecutors say flowed through Arizona's southern corridor, not despite the federal court system, but in part because of it. Because of one man in a black robe who knew which deportation orders to delay, which border warrant applications to scrutinize, which ICE informants to expose, and which cartel-linked defense attorneys to tip. 58 people are in federal custody tonight. The 58th is a federal judge. Exterior. Tonight, you will watch the most trusted institution in the American legal system unmask itself. Slowly, completely. This is how it happened. The operational plan for this arrest was not written in days. It was written over 3 years of surveillance, 17 months of grand jury proceedings, and a final 48-hour review by the Department of Justice's Public Integrity Section. A division that exists for one purpose: prosecuting the corruption of public officials. When they signed off, the arrest warrant was 9 pages long. Federal records show the go order was issued at 5:47 in the morning on a Tuesday in March. 33 FBI agents, an ICE Homeland Security Investigations unit of 11, specialists in cross-border criminal networks, cartel financial infrastructure, and human smuggling corridors. A second team operating simultaneously at a private residence in Scottsdale, 15 miles from the federal courthouse where the target had presided the previous afternoon. A third team at a law office in Central Phoenix, not the judge's chambers, but the office of an attorney whose name appears 41 times in the sealed indictment. All 3 teams moved at the same moment. Coordination ran through a secure federal channel that bypassed the Arizona District Court's communication infrastructure entirely. That bypass was not procedural, it was essential. Because when the institution under investigation is the federal courthouse itself, when the target has spent 11 years with access to sealed filings, warrant applications, pending ICE operations, and confidential informant identities, you do not use the building's own systems. You do not call the marshal service. You do not inform the clerk. You move clean. You move before dawn, and you arrive before anyone inside that building has opened their eyes. At 5:51, the Scottsdale residence of the Honorable Raymond Casillas, United States District Judge for the District of Arizona, is approached by federal agents for the first time in his 11-year tenure on the bench. Judge Casillas does not answer the door immediately. Federal records note a 2-minute, 14-second delay between the first knock and the opening of the door. A delay that agents on scene describe in their sworn affidavits as consistent with someone destroying or concealing materials. When the door opens, Casillas is in a suit. Not a robe, not pajamas, a suit. At 5:53 in the morning, the lead ICE HSI agent notes it in writing. It will be introduced at trial. He is placed in handcuffs at the front door of his own home. He says 4 words. According to the arresting agent's sworn statement, those 4 words are, "Who authorized this operation?" Not a denial, not a question about his rights, a question about who in the federal system had the authority to come for him. It is, federal prosecutors will later argue, the question of a man who believed he was protected, who had, for 6 years, been protected, and who now understood, standing in his driveway in a suit at dawn, that the protection was gone. The search of Casillas' residence begins at 5:58 a.m. and does not conclude until 4:22 in the afternoon. 10 hours and 24 minutes, 41 evidence markers placed across 12 rooms. What federal investigators find is not hidden in a panic room or buried behind a false wall. It is hidden in the most audacious place imaginable, in plain sight, inside a home office that contains a full set of judicial reference materials, a framed copy of the United States Constitution, and a locked file drawer containing documents that should not exist outside a secure federal facility. Investigation. Inside that drawer, printed ICE operational summaries for 7 pending border interdiction missions. Documents classified at the law enforcement sensitive level that Casillas had no legal authority to remove from the courthouse. Beside them, a legal pad, 14 pages, handwritten, containing what forensic analysts would spend 3 weeks decoding. The pad cross-referenced ICE informant code names with what appear to be physical descriptions, vehicle information, and last known crossing locations. It was, in the words of one senior ICEHSI investigator quoted in the sealed record, a targeting document for cartel enforcement against our own people. But the drawer was not what broke this case open. The drawer was the confirmation of what 4 years of investigation had already established, what broke this case open. What turned a corruption inquiry into a federal RICO indictment spanning 3 countries was a recording. A recording made not by the FBI, not by ICE agents, but by a Sinaloa cartel mid-level coordinator who, in the autumn of 2021, decided that his own organization had become a liability and walked into the FBI field office in Tucson carrying a burner phone. On that phone, 11 audio recordings. In one of them, a voice that a federal voice analysis unit would later match with 91% certainty to Judge Raymond Casillas, discussing in coded but decipherable language the timing of a border operation and the identity of a federal informant embedded in a Sonora-based smuggling cell. The FBI's Financial Crimes Unit spent 8 months working backward from that recording. What they reconstructed was a payment architecture of quiet, patient sophistication. No wire transfers in Casillas' name. No offshore accounts traceable to a sitting judge. Instead, a network of 9 legal entities, 3 registered in Arizona, 2 in Nevada, 4 in New Mexico, that on paper represented a portfolio of commercial real estate investments. In practice, they were conduits. Money entered through a Sonora-based import company, passed through a series of domestic LLCs, and arrived at Casillas through a consulting arrangement with a Phoenix law firm, a law firm, federal records show, that had appeared before his courtroom on 14 separate occasions in the preceding 3 years. Follow the money. In 6 years of payments, Judge Raymond Casillas received, according to the federal indictment, no less than $4.2 million in laundered cartel funds. Not in cash, not in wire transfers flagged by FinCEN, in property, in legal fees paid to entities he controlled, in a vacation home in Rocky Point, Mexico, purchased in his wife's name through a Sonoran real estate broker who appears separately in an ICE and smuggling investigation as an associate of the Beltran Leyva organization. His wife, federal prosecutors have stated publicly, is not a target of this investigation. The property is seized regardless. The full scope of the operation that Casillas protected runs to $1.9 billion across 4 years. The pipeline moved narcotics, primarily fentanyl precursor chemicals and finished product, northward through the Lukeville and Sasabi border crossings. It moved human beings, primarily economic migrants, and, in a documented subset of cases, trafficking victims, through a network of safe houses in Tucson, Phoenix, and Flagstaff. Casillas' role was not operational. He did not move drugs. He did not coordinate crossings. His role was judicial insulation, the removal of legal friction, the quiet burial of cases that came too close. Federal investigators identified 11 specific instances in which Casillas is alleged to have taken direct action to protect cartel-connected defendants or operations. 4 involved suppression of evidence rulings that ICE HSI agents, analysts now describe as legally indefensible on their face. 3 involved the unexplained recusal of Casillas from cases, only to have those cases reassigned to judges who subsequently issued favorable rulings. 2 involved the exposure of confidential informants, one of whom relocated under federal protection and one of whom did not. That second informant, a 29-year-old Tucson resident identified in court documents only by the initials DV, was found dead in the Sonoran Desert in July 2022. The case was ruled an accident by Mexican authorities. The FBI has not ruled it anything. This is where the taxpayers' investment in the federal judiciary enters the record. Judge Casillas earned $223,400 per year in federal salary, a salary paid by the citizens of Arizona and the United States. He received federal health benefits, a federal pension, and a security detail provided at public expense. He used the authority granted by that salary, those benefits, and that public trust to generate 4 times his annual income in cartel payments, while burying the cases of the agents and informants whose work those same taxpayers also funded. He was, in the precise language of the RICO statute, a criminal enterprise operating from within a federal institution. 58 individuals face federal charges tonight. Among them, the Phoenix attorney whose law firm served as the primary laundering conduit, a man who passed the Arizona bar examination in 1998 and who, according to the indictment, began accepting cartel referrals within 18 months of his first appearance in Casillas' courtroom. A Tucson commercial real estate broker who managed the property network. 2 ICE administrative employees, not agents, but personnel with access to case management systems, who are alleged to have provided operational scheduling information that allowed the cartel to time its crossings around enforcement windows. And Judge Raymond Casillas himself, facing charges of RICO conspiracy, bribery of a public official, obstruction of justice, and the charge that carries the gravest potential sentence, conspiracy in the death of a federal informant. There are communities along Arizona's southern border tonight that have spent years watching their neighborhoods used as transit points. Their families recruited as lookouts. Their young people offered money they could not refuse. Communities that filed complaints and made calls and sent letters and were told in various official ways that the situation was being handled. It was being handled by the man whose rulings were supposed to protect them. Those communities deserve to hear tonight that the system, the larger system, the one that answers not to a single courtroom but to the full weight of federal law, did not stop working. It just took 4 years and 44 agents and 1 informant who walked into a field office in Tucson with a burner phone and made the decision that changed everything. That informant, whose identity remains under federal protection and who has been relocated at government expense, is the reason this broadcast exists tonight. He is the reason 58 people are in custody. He is the reason the $1.9 billion corridor through Lukeville and Sasabe has been, as of this week, operationally disrupted. He made a decision that carried mortal risk in a city where the cartel's reach into the legal system had, for years, made such decisions appear futile. He made it anyway. Federal prosecutors, in a filing last month, described his cooperation as among the most consequential in the history of the Tucson field office. Judge Raymond Casillas will be arraigned in federal court. Not the Arizona District Court where he once presided, but a separate venue selected specifically to avoid any association with his former jurisdiction. On Thursday morning, he has entered no plea. His federal pension has been suspended pending resolution of the charges. His judicial appointments, 11 years of them, are under formal review by the Ninth Circuit. Every ruling he issued in a case involving cartel-connected defendants, ICE operations, or border enforcement is now subject to re-examination. That review, according to sources familiar with the scope of the inquiry, will take years. The investigation is not finished. The 41 evidence markers placed in Casillas' home residence on Tuesday morning are in federal custody. The 9 shell companies are frozen. The Rocky Point property is seized. The Phoenix law firm has been placed under federal receivership, and the 11 audio recordings from the Tucson informant's burner phone, only one of which has been referenced in the public record, remain, according to sources with knowledge of the case, the subject of an active investigation that extends beyond Arizona. Beyond the individuals named in tonight's indictment, ICE HSI sources speaking to this network on background described the recordings as containing references to public officials in at least 2 additional states whose names do not appear in any public filing, not yet. We will follow this case as the sealed record continues to open. The people of Arizona and every American who has ever stood in a federal courtroom and assumed, as we are taught to assume, that the person on the bench is there to serve the law rather than to sell it, are owed a complete accounting of what was done, of how long it was done, and of who else knew.